Yeah, to be honest, I never thought of the point that you made very aptly there when the text and data mining exception was introduced 2019, right, in the EU framework, that basically AI systems were not really thought of.
Do you think that moral rights are really conceptually capable of addressing these large-scale international dynamics, or would additional collective governance mechanisms be necessary?
Although for some authors, these digital environment and these technologies create also like a digital persona. So it's a digital you. Would that enable a concept that transcends the life of the individual? No?
I'm wondering whether this applies only to the EU member countries, or it's intended to be international in scope.
If, let's say, copyright works are truly broken down, into ones and zeros and merely represented with patterns, and no longer retain that expression that, is what requires protection, then would the harm that comes out from generative AI only be if the output, infringes on existing works? Or are you saying that the whole system of training models based on data is harmful in itself?
The Global South Network provides an important space to share experiences and learn good practices from one another.
Dialogue takes on a particular importance thanks to Global South Network, which allow us to believe in a better world of the rule of law.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provides a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Reayat, for the immense work that you're doing in the GSN, and the Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Good afternoon, everyone. It's my great pleasure to welcome you all to the 9th seminar in Phase 5 of the International Interdisciplinary PhDinprogress weekly seminar series organized by the Global South Network. I am the founder and chief convener of the Global South Network, Dr. Nauman Reayat, and I've been running these sessions since May 2023. My research interests lie within the areas of constitutionalism, rule of law, judicial independence, judicialization, and judicial populism, mostly in developing democracies. It's a real pleasure to chair today's session. It was supposed to be chaired by Dr. Jing Wang, but she's running late and she will join us very shortly. I'm joined by two discussants and two peer commentators. Dr. Başak Bak is the first discussant for today's session. Dr. Bak is a lecturer in law at the School of Law, University of Reading. Her research lies within the broad fields of intellectual property law and data protection and privacy law, with a particular emphasis on the regulation of artificial intelligence. Dr. Lucius Klobucnik is the second discussant for today's session. Dr. Klobucnik is a lecturer in law at the Aston Law School, Aston University. Genevieve Heng is the first peer commentator for today's session. Genevieve is a PhD candidate in law at the London School of Economics Law School. Her current research explores how copyright law and digital regulation work together to influence the digital creative process as a whole, owing to imperfect private enforcement initiatives by rights holders. Zifan Xu is the second peer commentator for today's session. Zifan is a PhD candidate at the School of Law, University of Manchester. Finally, it's my great pleasure to introduce our guest speaker for today's seminar, Jose Francisco Camarena, who is a PhD candidate in law at the City Law School, City University of London. Jose is a doctoral researcher at City St. George University of London, whose research focuses on the current challenges at the interface of recent data policy and regulation and copyright law. His thesis explores the implication of copyright in the datafication of works of authorship. He obtained his LLM degree from Duke University in the USA. He has collaborated with the World Intermediary Liability Project at the Center for Internet and Society at Stanford University and with the World Intellectual Property Organization Academy. He has practiced law for more than 15 years, recently as the intellectual property partner for a private law firm in Mexico City, and for many years taught intellectual property law, administrative law, and personal data protection in Mexico at the Monterrey Institute of Technology and Higher Education. Today, Jose will present part of their PhD project titled A Suitable INFOSPHERE, the underlying tensions in the European Union data law and their interplay with copyright law. He will speak for about 30 to 35 minutes, followed by 5 to 10 minutes of comments from our discussants. And if time permits, we will then open the floor for a 15-minute question and answer session with the audience. Jose, we are delighted to have you with us today. The screen is yours.
Thank you very much, and thank you all. Thank you very much. Okay, well, so basically what I tried to do in this presentation is just to focus on one of the sections of my PhD thesis, and particularly one that relates to what I call the underlying tensions in EU data law in general and their interplay with copyright, but also tapping from certain scholarship on philosophy of information and information ethics. And so basically what I do in this section of my thesis is to talk about obviously the European data strategy and how it was a platform for European data law, the recent developments, Data Governance Act, etc., all of those acts that you already know, and at the same time I talk about how this European data law, the landscape of European data law currently, it's one that spreads across various domains, including data protection law and intellectual property law, and how they interplay with the European data law in general. So I have basically noticed this, there's a conflated treatment of information concepts in the law. They are rather underspecified in law. Data, and this is in the literature of data science or philosophy of information, where data is a concept, a different concept than information, but in many EU regulations they are conflated, as if they were the same thing, and therefore that affects other information-related areas when they interplay with these definitions or the definitions that these particular regulations have enacted. For example, it's very well known that obviously copyright could not protect data as such if data is correctly understood as facts or as indicia of information or fragments of information, whereas according to philosophy of information is data plus meaning would be information, and therefore these single elements would not constitute information yet, and therefore they would not be protected. But at the same time, there's European legislation that basically, including, for example, the European Database Directive, etc., that treat the concept of data is conflated with information, and there's no clear distinction between them. And what that causes is, for example, that according to those definitions, copyright it's involved, or is implicated, because I cannot, let me see why I cannot change the, yeah, okay. So that's the first thing. And I have also noticed, or this, I remarked this dynamic tension within European data law, in which there's a dual approach to information as a personal semantic act of speech, obviously underpinned by fundamental rights, but also this reified notion of information, information as a thing, as a raw material, as a commodity, etc. This has this reification of information has developed for years, dealing with or arising from changes in technology, allowing for example, for different types of databases that are not anymore related to the typical database concept, horizontal, linear, hierarchical databases, but object-oriented databases, and from then on, information is becoming a different thing, data particularly, not information. But so therefore, data as a raw material, involving also extractive or exploitative practices, and is framed also within this fundamental rights approach that the EU has championed at home and abroad, and is that it prominently present in the GDPR particularly, which is the central piece of how and why the European Union has become like the data regulator, or has been emulated in other countries. So, and still there is a balanced, human-centric approach underpinned by fundamental rights still at the core of this legislation. And obviously, the tensions are also that, for example, in terms of data technologies or current data technologies such as generative AI, etc., they're also seen as a driver of investment. And there's the aim to regulate and promote these technologies, for which data is also a key input factor. And obviously, as in the data strategy, is to reduce barriers that could hamper these objectives, including, for example, IP rights. So there's obviously something, a tension or a conflict here, that the new Data Acts seek for aim for data abundance, access and circulation, accessibility, etc. And GDPR, on the other hand, is data minimization, purpose limitation, informed consent, etc. So now, what I do is basically I connect this with some concepts from philosophy of information, that including datafication, that is more than mere digitization, transforming or reducing natural phenomena or human activity to a quantified, tabulated form so that it can be analyzed and allows further and automated processing. So basically, also in philosophy of information, we have this concept of INFOSPHERE, which is the complete informational environment that comprises many informational agents and their mutual interactions. Luciano Floridi has spoken about this abundantly. And so the INFOSPHERE would also include offline and analog realms too, being more than just the cyberspace, which is only a particular region of this INFOSPHERE that has many agents, okay? So basically, some views think or consider that informatics has now encroached information. And so there must be a reappropriation from machines to the whole of the infosphere, because computation is only one amongst many information agents. And obviously they make the point that a sustainable infosphere should avoid policies that favor only certain agents or modes of production of information in detriment of other primary agents, or more as to preserve fundamental and qualitatively distinct agents. This with the goal of avoiding information entropy, aiming for information quality, variety, and also for values such as truth in public speech. So, of course, many governments are now privileging synthetic information, recombinant information, artificially generated information, via automated data processing, and also entailing a certain business model of commodified tech services. So for these authors that I'm reviewing, then, well, it prompted for me, I mean, the discussion about the legality and legitimacy of datafying works that are being used as training data for generative AI models, for example. It's just one of the possibilities or the interfaces between these two areas. And of course, we already know the discussion that is taking place, if authors should have a fair compensation, if works are used as input for commercial, particularly machine learning, etc., etc. And how also, on the other side, as AI firms capitalize and maximize unrestricted, unpaid exploitation of works for such purposes. And of course, at the center of this is the famous text and data mining exception in the Copyright and Digital Single Market Directive, Articles 3 and 4, where Article 4 basically is an exception to one of the fundamental copyrights, which is the reproduction right, one of the exclusive rights. Well, this is included in the, as I was saying, Article 4 of the directive, and it's obviously aimed for commercial purposes. It includes commercial purposes. And well, of course, the consequence of this is that obviously, for example, the reproduction, in the case of the reproduction right, because these exceptions also consider the database, the sui generis database rights, where there's also an exception for the extraction of these databases for purposes of text and data mining. But the reproduction right has basically been converted into a right to opt out, imposing even certain formalities for this opt out, for the exercise of this opt out. And of course, there are many critiques already there about this exception, because it was not originally devised with generative AI in mind, and it comprised solely data analysis, pure text and data mining, for which, in the case of pure text and data mining, obviously it's the outputs are very different and more limited. So many have discussed that they may not be the optimal path, and that could unfairly prejudice the material interests of the authors. And many, it's in the literature from Christoph Geiger, Giancarlo Frossi, etc. And so for many, Nicola Lucchi, etc., this exception should be at least amended in some form to take into account this situation. So it has been said also that this creates like a double standard, one for individuals and other for machines. Creators can do, individuals cannot do certain, are not allowed to do certain uses of works, whereas machines would be allowed to do the same. So there are many critiques regarding this exception, and of course we know that in other countries we have even broader exceptions. Japan, for example. The UK is still only for research purposes, but this is being discussed. And of course, in the US, we have the fair use doctrine, and we have a plethora of cases pending before US courts on this topic. China has no TDM exception, etc. So this is a wide array of exceptions dealing with this. So basically, for this authors that criticize this position, this would marginalize human creativity, disrupt sustainability of human authorship, prevent humans' creativity from becoming, an adequate amendment of this exception could avoid creativity becoming purely instrumental or a raw material for generative AI, etc. So there have been proposals, for example, establishing a levy system, statutory remuneration right for commercial machine learning, etc., and replacing the current opt-out regime established by this directive. So what I would say my view on this was that these proposals only entail economic or material interests of the author. So what about the personal interests, the non-economic incentives, including personality rights, for example? So I'm making parallels with some parallels as an exercise with data protection rights, that even with all their limitations and the critique we could have on them, they have promoted important fundamental rights, created awareness on informational self-determination. They have more or less empowered citizens in the digital and data-driven landscape, and they have created this fundamental Brussels effect, the European as a legislator for these topics. So I was searching for a synergy between both domains, and this is not new. There's an old article by Pamela Samuelson in 2000, and then she was already talking about how copyright could be, like a tool for data protection rights, etc., and vice versa. Maurizio Borghi and Stavroula Garapapa, in the famous work of mass digitization, they already discuss the possibility of adapting certain tools from data protection rights to the mass digitization challenges that copyright is facing. So what I do is I try to establish a connection between the fundamental, the core of both rights. There's a Kantian connection there, because obviously the foundation of data protection rights is morals. It's based upon moral self-determination, autonomy, as Kant understood it, and that's the basis for what we call informational self-determination rights. Whereas there is also a Kantian approach to copyright that deals with copyright as speech, and speech also as essential for self-determination. So in this space, they would converge both as personality rights. So copyright as a communicative act, as speech, becomes also an essential part of self-determination, and also aligns with some of the goals of informational self-determination. So for me, that was the beginning and that's what this chapter is about. And obviously, I suggest that moral rights, in a way, could contribute to this. And moral rights align with many fundamental rights goals contained in various international instruments. And so I'm not going to mention them all, but they're very well known. The International Covenant, the Convention for Human Rights, etc. So the Charter, etc. Because obviously they entail this aspect of freedom of artistic expression, the protection of the moral interests of creators, and the work as an imprint of the personality of the author. So in a way, these rights protect the personal and reputational value of creative works. In many countries, also the problem is that there is a varied landscape of how these rights are conceived. In most countries, they are inalienable. They survive the transfer of economic rights. They're unwaivable, imprescriptible, etc. And also, like data protection rights, they are premised also on the exercise of these rights, premised upon the individual control of over information. Obviously, Article 6b of the Berne Convention that enshrines basically this set of rights includes mainly the right of attribution, to claim authorship, to be credited as the author, the right of integrity, to object to any distortion, mutilation, modification, derogatory action in relation to the work prejudicial to honor or reputation. Of course, there's more robust protection in many other countries. France is an example, but also Germany, and countries which do not require the reputational component or element in Berne, in 6 and also that may include the destruction of the work, like including the US, like the Visual Artists' Rights Act. So there's been mention in the literature, even from 2021, that acts performed during the datification of works for data processing may constitute infringement of moral rights, or that at least moral rights may be implicated in those uses. So I'm also establishing here that the moral rights serve a public interest and have a collective dimension. So basically, they also could work, let's say, like a private right, but a private right that also serves a public function. That's my view. So which public function? The same public function that information ethics and philosophy of information is talking about, to preserve accuracy, veracity, information integrity, etc. That was something that the literature in, for example, library science, etc., and how to preserve documents and information sources, etc., has dealt with for many years. So in this sense, moral rights could converge with these objectives or goals, like information quality and variety, as understood as well-formed, meaningful, and truthful information. And as Luciano Florido says, to preserve the intrinsic value of information objects, with the difference that moral rights are hard law, so it's not a soft law instrument, but they converge with soft law objectives on AI, for example, such as the ones contained in the UNESCO recommendation on the ethics of AI from 2021, or others. So some authors have mentioned that the reliability, integrity, and authority of information is a crucial issue, and moral rights could be more important than ever. Problem is that moral rights are not harmonized in the EU, obviously, therefore not included in the text and data mining exception of the directive. But they are also important because they could avoid this threat of information homogenization, INFOSPHERE on sustainability, and there's a comment in the literature about the possible collapse of AI models if they only use and reuse synthetic data. So, of course, moral rights also have their own internal inconsistencies. Maybe a future harmonization could fix that. Originally, harmonization has not been addressed because it was thought that it was not necessary to achieve the goals of the common market, etc. But maybe that conception has changed, so they could become even more relevant in the context of data technologies. Of course, they would need certain amendments, modifications, etc. And this has been said at least from French scholars since the rise of the online world and digitization. André François was one of them, and of course, in my analysis, what I also discovered is that there are challenges that they share with data protection too. This personalistic approach to individual control limits the exercise of these rights, or is inappropriate because of the network structure or the aggregated value, the aggregated form in which data is used by these data processing technologies. That's also part of their objectification of information, is how information is used, not as a communicative act, but as a thing, as a material. So because the goal now is to manufacture information, not to just communicate it as when the online world began or the session began. So those challenges are shared by both domains, no? Data protection and copyright. So I'm in this, as part of this this section of my thesis, I'm also proposing that certain collective mechanisms for the exercise of these rights are required, and also collective redress, etc. And I'm trying to connect this with recent developments in data protection and the collective exercise of these rights. And well, that's basically that's a big part of this section, because of course the evidence of the infringing acts is problematic. We know that, and of course the AI Act, the obligations, the transparency obligation and risk mitigation obligations that are included in the AI Act could help, Article 50 and 53, although they only apply to AI model providers, not to the other actors in the chain, etc., or the pre-training stages, etc. So there's a problem there. There's a liability issue. It's complicated. Now, of course, we know that all of this is going to move to a platform logic, and so we already have lessons learned from obviously intermediary liability of platform of online platform providers, etc., content providers. Sorry, so that's also an interesting area, and so I'm also exploring the interplay with the data protection law and the rights provided by these rights to deal with these issues. And so, well, I mean, that's basically the. Of course, this is a work in progress, and I'm just establishing these parallels between and these tensions between these two domains, and I'm exploring further certain solutions. But that's basically what I'm doing. Yeah. Thank you very much.
Thank you, Jose, for an excellent presentation. Allow me to invite our first discussant, Dr. Başak Bak, for sharing their comments. Please, Başak, over to you.
Thank you so much, Jose. That's a very interesting presentation, and I would like to just briefly give some feedback on your abstract and the presentation, and then I would like to ask some questions. You don't necessarily have to answer them now, but these are just for food for thought.
Yes.
Although you are more than welcome to discuss them if there's time and if you would like to discuss them. From the abstract and your presentation, my understanding is that the paper your research explores tension in EU data law between weaving information as a communicative act grounded in fundamental rights and treating it as an economic resource in the data-driven economy. And then I think your research considers then how these tensions emerge in the interaction with EU data regulation and copyright law, particularly in the context of generative AI and the idea of sustainable infosphere, which is quite interesting. I'd like to start by saying that I find the conceptual framing of your research particularly interesting, especially this distinction between information as communication and information as an object. And I think the abstract does a very good job of clearly framing this tension and identifying the problem. I also like how you have picked a very timely topic, particularly given the rapid development of generative AI and increasing datafication of cultural and informational resources. So, to me, it's very clear why this research is both timely and important, but, well, this is my area. I might be biased, of course. Regarding your presentation, I think you did an even better job clarifying the research question and the method, because one thing that I noted here when I read the abstract was that the abstract lacks the research question and method. So now, after hearing this presentation, it became clearer that the paper, that your research goes beyond diagnosing the tension between information as communication and information as an economic resource, and instead points toward, strengthening moral rights as a possible response to these challenges. So now, after the presentation, I can clearly see the question and method are there, which is a good sign, always a good sign. And I also like the concept of sustainable infosphere. And from your presentation, again, it became clear to me that it refers not only to economic sustainability, but probably more like the quality of the diversity of the informational environment. So the method there is there, the research question is there, conceptualization is good, and these could have been embedded in the abstract as well, but the presentation covered them very well. I quite enjoyed it. I have some questions. I used to have 3 questions. You answered one of them, but I'm not going to mention this question as well, just so that you understand the part that is interesting and important to me. First, you talked about the conceptual tension, the thing that I mentioned, the information as communication, information as an object. So my first question is, do you see this tension as primarily normative or as more structural? I mean, in what I ask here, do you think that this tension is something that could be resolved through legal clarification, for example, or is it an inherent feature of how EU law governs data and information in the first place? I think this is important because a more emphasis on this, whether it's a normative problem or a structural one, I think would significantly and automatically improve the rigor of research. And the second question was about moral rights, but I think you answered the question in the presentation. So I'm going to say it anyway, because I am one of these authors who think that moral rights serve a public interest. So I understand what you mean. In fact, I published a paper like a few years ago. It was about copyright, authors' right of withdrawal for change conviction and its interplaying with the right to be forgotten in the GDPR. And the argument was there that moral rights are probably the only thing that is left to us in this era of automated decision making that is left to us as humans. But I also think that, and I thought exactly the same when I listened to this presentation, as you know, moral rights are traditionally individual and personality based, while the challenges created by generative AI and large scale data practices appear to be more systematic and collective. So do you think that moral rights are really conceptually capable of addressing these large-scale international dynamics, or would additional collective governance mechanisms be necessary? You suggested additional collective governance mechanisms are necessary, but I still think that maybe you need to think more on whether moral rights are conceptually capable, given that they are also the least harmonized topic in copyright law. So I think this point is quite important, which I understand you partially answered. So, which brings me to my final question, the third one. Does the concept of sustainable infosphere, according to you, which seems very central in your argument, refer mainly to the ethical governance of information ecosystems, or, does it refer to balancing access to information with control over data and creative works? Or does it refer to perhaps a longer term regulatory coherence in digital environment? I think clarifying this a little bit more on that might help further highlight the normative contribution of the paper. I'm not just merely asking or suggesting the literature review, but I'm asking your understanding of the concept a little bit more, because if we can easily see where your argument fits in the main debate, this would again automatically increase and improve the significance of the research. So these are my questions. Again, not necessarily I'm expecting answers, but more like food for thought. But I am also very interested to hear if you have any right now. Yeah, so overall, this research, I think, raises very important questions with clear method and conceptualization and research question. And I really look forward to seeing how this work develops further. Thank you so much again.
Thank you very much for the
Thank you.
Yeah.
Thank you, Dr. Bak, for very useful feedback. Jose, may I suggest we go to Dr. Klobucnik, collect feedback from the peer commentators, and then you can respond to them collectively. Is that okay with you, Jose? Thank you very much. Dr. Klobucnik, over to you, please.
Right, thank you so much. Hello, Jose. This is a fascinating topic, and your presentation was really, really interesting. So thank you so much for that. And of course, you've been hearing these complaints, especially by creators who basically say that copyright is essentially being degraded to data. So I was wondering, if you're approaching a topic as yours, I'm assuming you have a legal background. How much kind of technological understanding do you need to have? So, for instance, from that metadata perspective, so from the way how it works, on the technology level, how would it be possible, perhaps, to distinguish a copyright protected work from any other information, if we're just looking at potentially zeros and ones in the digital environment? So I was wondering if you have an answer to that, or if you're if that is also part of your research. And yeah, to be honest, I never thought of the point that you made very aptly there, that when the text and data mining exception was introduced, correct me if I'm wrong, in 2019, right, in the EU framework, that basically AI systems were not really thought of. So so I was wondering, perhaps, what was kind of that rationale to introduce this exception, and then how does it then play out potentially with the British suggestion, this well-known option 3 in the copyright and AI consultation, which to me verbatim looks the same, but I guess this very much came in when the AI systems were already around. Mm-hmm. So I was wondering if the considerations on the EU level were then different than in the UK. And two other very short points. Also, I think that the moral rights angle you're adopting is a really good one there, and it offers some potential to explore. So I was wondering if you think of harmonization. So for your suggestion to work, would you say that moral rights would need to be harmonized on the EU level? And perhaps a slightly provocative question or comment, now is it actually easier would it be easier to harmonize EU moral rights law after Brexit? So
yeah.
obviously as British moral rights being slightly different to the continental European ones. I guess the chance might be there. So I wonder what is your view on that. And last, when you mentioned those collective mechanisms, if you can somehow elaborate on them. So, for instance, my research interest lies very much in copyright, collective management, collective societies, and I know that some of them actually managed to successfully exercise this withdrawal of their members' works for data training. But I was wondering if they could be somehow involved in that, in those debates or in the collective measures, or the measures that you thought of were different. So thank you again, and again, it's a fascinating research, and I'm looking forward to seeing how it develops.
Thank you.
Thank you, Dr. Klobucnik, for very insightful feedback. I'm sure Jose will be noting all those points and questions. So what I can do is, let's go to Genevieve, the first peer commentator, and collect their feedback. Genevieve, are you there?
Hi, yes, I'm here.
All right, okay, please, over to you.
Yeah, thank you so much for the presentation. That was really interesting, and I really enjoyed it. And I can totally see your vision for the project and how it will affect the INFOSPHERE as you described it. So all comments that I'm making here are mostly just to play devil's advocate. So I was just wondering if you could maybe elaborate more on what you think the harm is here, because if, let's say, the harm of all this data harvesting and data analytics, because if, let's say, copyright works are truly broken down into ones and zeros and merely represented with patterns, and no longer retain that expression that is what requires protection, then would the harm that comes out from generative AI only be if the output infringes on existing works? Or are you saying that the whole system of training models based on data is harmful in itself? So if you could provide more elaboration on what this harm you envisage is, that would be great. And secondly, about the part of your presentation when you talk about borrowing principles from data protection and applying it to copyright. So my thoughts are that, there are obvious groundings and justifications for the protection of personal data, right? Because it's sensitive information. We don't want it to be exploited or shared with the world. But I'm wondering if there's the same grounding to be found in copyright, such that it merits this transposition of data protection principles over to copyright. Because, even though obviously copyright, fundamental right in itself, very important, but other than the justifications in terms of granting authors their reward and also, socioeconomic incentives to create, it also has to similarly support follow-on creation. And I'm worried if, let's say, we apply the data protection principles over, will we be essentially kind of overprotecting copyrighted works beyond what is actually needed to justify the right? And whether or not you have thought about any protections that can be given to follow on creativity to prevent this overprotection of copyright. But otherwise, I really enjoyed the presentation, and thanks so much.
Thank you.
Thank you, Genevieve, for your comments. Zifan, are you there? And can you please switch on your camera? Go ahead, please.
Yeah, thank you very much for the presentation. I think it's a very structured presentation, and because I focus on the copyright, so maybe I have some questions about the copyright, and I think you mentioned the additional collective governance mechanisms are necessary, but I think your analysis centers on the EU law. So I'm wondering whether this applies only to the EU member countries or it's intended to be international in scope. Because I think if it only applies to EU countries. As we know, each EU member state has its own laws and policies, which can differ significantly. So, can more rights really achieve these harmonious conditions across them, and can these connective governments be truly realized? I think that if you want to apply to the international level, I think maybe you focus on EU law. It's not focus on the other countries, and this may be a question. But I think you have answers about this one, so maybe you can get some further information about this one. So, but I think other parts is well structured and very interesting. So that's my comments. Thank you very much again.
Very much, Zifan, for your stimulating comments. Jose, all said, all done. Ball is in your court now. Feel free to comment.
Thank you very much for all the questions. They're very insightful. I mean, and for sure they will help me to refine my research. I'm noticing even now. So, see, yeah, of course, there's a lot of stuff here. So I don't know. It's impossible to address them all, beginning from the last. Regarding EU member countries, and yes, of course, moral rights differ a lot from one country. Well, not a lot, but some rights, yes, they do differ. And I'm addressing that point. And one of the chapters is precisely about the reasons for harmonization, and touching upon what Lucius was saying. Is this the right timing? Because now after Brexit, and yes, of course, we know that common law countries have a different perspective on these rights. And yes, of course, that would facilitate the issue. And on the other hand, I think that the problems or the situations that are being enabled by these new current data technologies would help to justify even more the need for this harmonization. Even before this, there were already scholars commenting about on this need to harmonize. But now maybe it's the right time to at least suggest or propose. So of course it's difficult. It's going to be difficult, but less difficult, I think, than it was in the past. And obviously the output input as to the output input divide, and if there was a question on only output infringes or the whole process is harmful, etc., etc. So it's also part of my research was that, well, you cannot necessarily, I mean, you have to for analytical purposes, but it's a little bit to oversimplify it if you divide it in rigid stages such as input or output, because there are outputs already in the input phase. I mean, there are outputs that are already in that phase, that occur in that phase, and not only at the so-called downstream, let's say it's a more appropriate term, downstream stage or upstream stage. And so I think that what I tried to do is to connect them both. Of course, at some point dealing with infringement, you have to, for the sake of analysis, separate them. But on that topic, I think that, well, now there's, and this also addresses the question about the technicalities and the technical detail of how this technology works, etc. on which I have an entire chapter on that, but to link certain specific details on the technology to certain infringements. And now that we have, when I began this, not many authors were discussing certain parts of the process. Now we have more papers on that and what happens more and more, what happens inside. And now we already have courts that have addressed that GEMA versus OpenAI is one. Of course, it's just probably would be appeal, etc. But at least there are courts already acknowledging these facts of memorization, etc. What happens inside the model? For example, I devote an entire section of a chapter to what vectorization is, to create vectors from the data, let's say, and what this vectorization entails, or the latent vector space. So what is that? And we can see that, of course, even if it has been treated as a reproduction, for example, by some of these courts or these scholars, there are more problems because it also implicates other rights, such as adaptation, by the way. And so I'm also making the link with this because it has been less explored, because obviously we've concentrated on the reproduction right, because obviously throughout the copyright history, reproduction right is the most salient right, and technologies have been looked primarily as reproductive technologies or technologies that infringe the reproduction right since the printing press onwards. So, but there are other rights that may be implicated. So I'm also touching upon that. Let me check. So the technical aspect. Oh yeah, well the first questions were super useful for me too, because I hadn't heard of it, and if I would like to read this article, Başak, that you wrote about this withdrawal, right, the moral right of withdrawal, and the data protection equivalent, because at some point in one of my chapters I touch upon the fact that this reification of information, for example, has impacted the portability, right? And it's also very important. So I would be very interested in reading that, and also about the ethical governance, that you mentioned, that how this balancing occurs. I have to refine this concept on the long-term coherence in the digital environment of these, and if moral rights are an adequate tool for this. They could be, but obviously there should be modifications. For example, I was having a discussion yesterday about this, on the point precisely that how is it that a highly personal right, such as moral rights, and a highly personal right, such as data protection, moral rights can be exercised by heirs when the author dies. I mean, and it's something that, for example, data protection rights, you can. I mean, it's so personal, no? And maybe so it's a limitation that we also have to introduce, although for some authors, these digital environment and these technologies create also like a digital persona. So it's a digital you, okay? So basically, would that imply or enable a concept that transcends the life of the individual, no? Like your heirs should take care of your digital persona, and I don't think that the extension of moral rights to that end would be justified, and on the contrary, that would undermine moral rights, rendering more and more obsolete, and so people basically would say this set of rights doesn't work for this world, like basically. And so we don't want that. Well, I don't want that. So it's because I think they're useful. And so I think that those changes, amendments would have to be made. Certain waivers could be introduced, not as extensive as the ones that, for example, in the UK rendered moral rights basically, I mean, useless, not useless, but I mean, like reducing their scope very much. I wouldn't be for that, but but certainly you have to balance them in a way, in a certain form. Sorry, I don't know. There's many other questions that I didn't.
Great, Jose. That's great. I think I will speak for all if I say that it's the PhD in Progress project, and you don't need to answer all questions. I think you can process, note it down, and whatever you find it relevant, useful, and after consultation with your supervisors, process it for further consideration. Thank you very much. Let me first, the teams, the way team work is very funny nowadays. So you have to change the features and then, okay. Great. All right. Okay. Thank you very much for such an insightful and stimulating presentation, Jose. Clearly, I can say I was able to follow the presentation, even though it's not very much directly related to my area, but the bottom line was very clear, and the comments were also very clear, useful. So your work clearly makes a valuable contribution to the broader discussion on EU data and copyright law, and it has given us much to reflect on. My heartfelt thanks also go to our excellent discussants, Dr. Bak and Dr. Klobucnik, and to our peer commentators, Zifan and Genevieve, for their thoughtful and engaging feedback, and to everyone who joined us today for your participation and support. The Global South Network warmly welcomes PhD students from all disciplines and from every corner of the world to share their research and receive interdisciplinary feedback. If you are interested in presenting your work or taking part in a future session in any capacity, please contact me. Feel free to do so at the email address leicgsn@gmail.com. Goodbye, everyone, and thank you once again for being with us.
Thank you very much.
Yeah, thank you so much.
Thank
Thanks
you
so
very
much
much.
for the great work.
Bye-bye. Thank you.
Cheers. Bye. Have a nice day.
Thank you. Bye-bye.